Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled U.S. Supreme Court Case Docketed. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, I would like for you all to hit that like button, and also if you're new to my channel, hit that subscribe button, and also hit that notification bell so you all can be notified as I'm dropping these powerful videos. So without further ado, let's get to it. Okay, so now, before I proceed forward, I would like to give a special shout out to my ARC. We have been fighting this case for quite some time, guys. It has been a fight. So to you, ARC, continue to stand firm. We almost at the finish line. Let's get this remedy, ARC. Okay? As we know, the U.S. Supreme Court only select 1% of their cases. But with me and you and the power of the Most High, ARC, I believe we're going to win this. We just have to stand firm, okay? So now, as you all can see on the screen, this is a letter that my ARC received from the United States Supreme Court, right? And it states, Supreme Court of the United States, Office of the Clerk, okay? My ARC name I crossed out. The case information I also crossed out. Then it states, Dear Mr. Blank, the petition for a writ of certiorari in the above entitled case was filed on May 30th, 2023 and placed on the docket December blank 2023 as number blank. Forms are enclosed for notifying opposing counsels that the case was what, guys? The case was docketed, okay? Signed by the clerk of the court, okay? So now you all can see my ARC case has been docketed with the U.S. Supreme Court. When I say we have to fight the good fight, guys, we have to fight the good fight. Okay? So now we're going to go over the other documents that was attached, okay, that my ARC have to send to the opposing counsel to notify them that the case was in fact docketed, okay? So without further ado, let's go there. Okay, so this is the second document that my ARC received from the Supreme Court of the United States. As stated above, it states, again, Supreme Court of the United States. The petitioner name I crossed out, who is my ARC. The respondent name I also crossed out. And also the case number I also crossed out. And it states what? To blank counsel for respondent. So this is for my ARC to send to the counsels for respondents, okay? And it reads, notice is hereby given pursuant to Rule 12.3 that a petition for a writ of certiorari in the above entitled case was filed in the Supreme Court of the United States on May the 30th, 2023 and placed on the docket December blank 2023. So now, guys, as you all can see, it says pursuant to what? Pursuant to Rule 12.3. So now let's go to Rule 12.3 real quick. Okay, so now, as you all can see, we are in fact coming from Cornell Law School. Let's pick this up where it states Rule 12.3, notice of a public authority defense. But now let's scroll down to 3. And it reads, response to the notice. What notice? The notice that we just started reading. Okay, let's read it. It states, highlighted in blue, an attorney for the government must serve a written response on the defendant or the defendant's attorney within 14 days after receiving the defendant's notice, but no later than 21 days before trial. Then it states the response must admit or deny that the defendant exercised the public authority identified in the defendant's notice. So again, guys, that's what Rule 12.3 means, okay? So now let's go back to the letter and let's pick it up where we left off from. Let's go there. Okay, so now we're back. Let's pick this up where it's highlighted in blue, where it states pursuant, and it reads, pursuant to Rule 15.3, the due date for a brief in opposition is Monday, January the blank 2024. Then it states, if the due date is a Saturday, Sunday, or federal legal holiday, the brief is due on the next day that is not a Saturday, Sunday, or federal legal holiday. But again, as it states what? Pursuant to Rule 15.3, the due date for the brief in opposition is what? Monday, January blank 2024. So now let's go over Rule 15.3 like we went over Rule 12.3. Let's go there. Okay, so now we're back at Cornell Law School, but this time we're coming from Rule 15. Let's pick this up at the top where it states Rule 15, briefs and oppositions, reply briefs, supplemental briefs. But now let's go to point 3 because it says 15.3. 3 states what? Any brief in opposition shall be filed within 30 days after the case is placed on the docket, unless the time is extended by the court or a justice or by the clerk under Rule 30.4. 40 copies shall be filed, except that a respondent proceeding in form of proprius under Rule 39, including an inmate of an institution, shall file the number of copies required for a petition by such a person under Rule 12.2. Then it states, together with a motion for leave to proceed in form of proprius, a copy of which shall proceed and be attached to each copy of the brief in opposition. Then it states, if the petitioner is proceeding in form of proprius, the respondent shall prepare its brief in opposition, if any, as required by Rule 33.2, and shall file an original and 10 copies of that brief, whether prepared under Rule 33.1 or 33.2. The brief in opposition shall comply with the requirements of Rule 24, governing a respondent's brief, except that no summary of the argument is required. A brief in opposition may not be joined with any other pleadings, except that any motion for leave to proceed in form of proprius shall be attached. The brief in opposition shall be served as required by Rule 29. So again, this is exactly what Rule 15.3 states on that document, guys. So they have a certain amount of time to file a response to the responsive notice, okay? Which was also attached to a brief or memorandum. So now let's go back to the letter and let's continue reading. All right, so now as you all can see, we're right back at the letter, but let's pick it up where it's highlighted in blue. And it reads, beginning November the 13th, 2017, parties represented by counsel must submit filings through the Supreme Court electronic filing systems. Then it states, paper remains the official form of filings, and electronic filings is in addition to the existing paper submission requirements. Attorneys must register for the system in advance, and the registration process may take several days. Then it states, for further information about the system can be found at the website below. Then it states, unless the Solicitor General of the United States represents the respondent, a waiver form is enclosed and should be sent to the clerk only in the event you do not intend to file a response to the petition. Then it states, only counsel of record will receive notification of the court's actions in this case. Counsel of record must be a member of the bar of this court. And it has what? My ox name at the bottom, who I crossed out, because you have to send this document to who? To the opposing counsel. Then it states what? Note, this notice is for the notification purposes only, and neither the original nor a copy should be filed in the Supreme Court. Okay, so now guys, let's go to the waiver form, as it states that waiver form will be sent with this document. So now let's go to the waiver form. Okay, so now as stated in the notice, this is in fact the waiver form that was included in the packet that Ma'ak received from the Supreme Court of the United States. And he must do what with these forms and notices, guys? He must mail them to the counsel for the opposing party to fill out. Okay, so now let's read the waiver form. And it states, waiver, Supreme Court of the United States, case number I crossed out, the petitioner and respondent name I crossed out. And it reads, I do not intend to file a response to the petition for a writ of certiorari unless one is requested by the court. And they must do what? Check the appropriate boxes, okay? That's it. That's all, guys. Then they have to sign, date, fill out their law firm information, and mail a copy back to Ma'ak, and also file a copy with the clerk of court. And it's just that simple, guys. So now I want to show you all the stages that we must go through in order to prepare for this fight. So now let's go to justia.com to get better understanding. Let's go there. Okay, so now, as you all can see on the screen, we are in fact coming from justia.com. Let's pick this up where it states, stages of a Supreme Court case. And it reads, the Supreme Court may be the first court to hear a case in rare situations, such as disputes between states. However, it is generally limited to hearing appeals from other courts. A case may come to the Supreme Court from a U.S. Circuit Court of Appeals, which heard the initial appeal of the case. The Supreme Court also may review a case decided by the highest court in a state if it hinges on questions of federal law. The Supreme Court will not review a state court decision that is based on separate, adequate, and independent state grounds. And it further reads, appealing a decision to the Supreme Court triggers a series of specific procedures. This overview explains each step from the initial petition for review to the final publication of opinions. Then it states, writ of certiorari. Let's pick this up at the top. And it reads, there is no absolute right to have the court hear an appeal. Someone who wants to appeal to the court must file a petition for a writ of certiorari. The justices will receive briefs and potentially amicus briefs on whether the writ should be granted. They then would decide at a conference whether to grant the writ. Briefs, amicus briefs, and conferences play a larger role later in the case and are discussed in more detail below. This decision does not require a majority. Only 4 of the 9 justices must agree to grant a writ of certiorari. This tells the lower court to prepare the record for review by the Supreme Court, and the case is placed on the Supreme Court docket. So again, guys, that's the reason why we did what? That's the reason why we filed the writ of certiorari. In order to get what? In order to get the case heard before the Supreme Court. Okay? But now let's continue reading. It states, if the court denies a writ of certiorari, the decision of the lower court stands and the case ends. This happens in the overwhelming majority of cases. So again, guys, majority of the cases that's brought before the United States Supreme Court are denied, okay? But that's not going to hinder us or make us feel some type of way. We're still going forward and we're still applying pressure no matter what, guys. But let's continue. It states, only a tiny fraction of these petitions are successful. The court may be more likely to grant a writ of certiorari if the lower courts have reached clashing decisions on the issue, or if it has a broad national significance. Then it states, granting a writ of certiorari does not necessarily mean that the court thinks that the lower court was wrong. However, the court recently has reversed much more than it has affirmed. So 9 times out of 10, guys, if the writ of certiorari is granted, then it's a stronger chance that your case will be reversed and you will win that case. Okay? And then after the writ is granted, then you must file your what? Your briefs and argument and support. Okay? After that, your if needed, you know, you can file an amicus brief. You all can pause and read it to find out what an amicus brief is. After the briefs are filed, then you all are going to oral argument. Okay? After oral argument, there's a conference. Okay? You all can pause and read it. After the conference, there's a voting. Okay? After the voting, there's the opinion. And then after the opinions, there's the publication. Okay? And that's the final outcome of the case. So I just wanted to show you all that we are in fact applying pressure. We are now in the United States Supreme Court, which is the highest court of the land. If we get in and we win, we will set precedent, guys, and we will change a lot. Okay, especially for the state that we're fighting. So again, that's what I'm gonna do for today. If you all need my help, hit me up in my email at y'allismagnified@gmail.com. Let's continue to apply this pressure, guys. Let's get this right wisdom, this right knowledge, and this right understanding. As the case proceeds on further, I will let you all know. But as I stated, win, lose, or draw, we are extremely excited. We like to give all glory and honor to the Most High Yah, because without Him, none of this is possible. And with that being said, cop that merch, guys. And again, if you need my help, hit me up at my email at y'allismagnified@gmail.com. And I say shalom.